involved in class action. So he's going to give us a general overview of class action. Then we'll move on to a more legal thing. Good morning from Lagos, Sam, and good to have you here. I'm hoping you can hear me well.
Thank you for having me. I can't hear you well, but I think these are grounds for class action. But I hope you can hear me well.
Yes, we can. Yes, we can.
Okay. Okay, great. Thank you for the generous introduction. I'm proud and honored to speak as a member of the faculty of CIAPS, to speak to you. As was made clear in the introduction, I am not a lawyer or a legal practitioner, but I've spent many years as a banker, venture capitalist, economic advisor to governments, and so I've been involved throughout my career in dozens of class action lawsuits. I have a pretty rich experience in the field, unfortunately. So I will start by telling a common myth. There's a tremendous echo. Are you hearing me well? Because on there is echo. Just someone let us know that you're hearing me well. Okay. So I want to start by dispelling a common myth. Class action lawsuits go both ways. You can have a class action lawsuit as a defendant. If you're attacked legally, if you're challenged, if you're sued by multiple complainants or multiple plaintiffs, you can at that point actually ask the judge to allow you to have a defendant class action. So class action goes both ways. That is very important to understand. The heyday of class action was in the 1980s and 1990s, when I was still in business and finance and so on and so forth. Today, class action lawsuits are much less common. In some jurisdictions, for example, in Switzerland, class actions are forbidden. In other jurisdictions, including in the United States, class action lawsuits have been severely restricted and limited. In the European Union, there is the famous Collective Redress Directive, Directive 1828 from 2020. I will read to you the title of the directive, and it will be immediately clear that the directive actually limits the ability to file a class action. It's not in favor of class action. It's about limiting class action lawsuits. So here is the title of the directive in the European Union. Directive on representative actions for the protection of the collective interest of consumers. So the collective redress in the European Union is limited to consumer-related lawsuits, nothing else. In the United States, there have been a series of legal developments. I will deal with them in a minute. But first, let us define a class action lawsuit or a collective redress lawsuit or what is known as an association lawsuit. There are many names. In some countries, it's called a class suit. In other countries, it's called representative action. In some countries, it's called association lawsuit or organization lawsuit. What's the essence of all these types of lawsuits? It's when a group of people, knowingly or unknowingly, have been damaged or injured by the action or inaction or by the product of a defendant. So we have a group of complainants, a group of plaintiffs, and we have a defendant. The complainants and the plaintiffs have been somehow injured or damaged or suffered some kind of loss. But here is the difference between class action lawsuits and regular tort lawsuits. In action lawsuits, the complainants and the plaintiffs don't need to be present in the court. Everything can happen in their absence. Additionally, in class action lawsuits, the complainants and the plaintiffs don't need to know that they have been damaged or injured. They don't even need to know that there's a class action lawsuit. And here we are beginning to see the first problem with class action lawsuits. They violate due process. And because they violate due process, there have been a series of legal developments in many, many countries, especially in the United States, but not only in the United States, in the United Kingdom, in the European Union, in India, in Australia, and so on and so forth. In the United States, for example, there are obligatory arbitration clauses, and there are laws that mandate arbitration rather than class action lawsuits. In the United States, a potential defendant, for example, a corporation or an institution, a potential defendant can introduce into its contracts a class action waiver paragraph that disallows class action in case of disputes. In many jurisdictions, you cannot have class action, or it's very difficult to obtain the certification of a class action. And instead, what you have, what's open to you as a plaintiff or a complainant, is what is known as mass tort or mass action. There are major distinctions, major differences between mass tort and class action. In mass tort, for example, the plaintiffs have to be present in court. In mass tort, each plaintiff must be questioned, present evidence, and so on and so forth, etc. So there's a huge difference between class action and other options of mass action. There have been many problems with class action over the past few decades. There were many unscrupulous lawyers who took advantage of class action in order to get rich quick. And the plaintiffs and the complainants ended up with nothing. This is known as coupon settlement because they ended up with coupons. Class action lawsuits have been used in unsavory ways. There are many prominent legal scholars, such as Posner and others, who claim that class action lawsuits are actually a form of corporate extortion or corporate blackmail. Corporations, defendants, protected themselves by colluding with groups of complainants and defendants within the class action, by colluding with subclasses in a process known as reverse auction. So gradually, over the past few decades, class action lawsuits have actually fallen out of favor. Now that's very unfortunate. That's very unfortunate, because the idea of class action lawsuit, which is, by the way, nothing new at all. The first class action lawsuit was filed in the year 1200. That's like 800 years ago. So it's not a new idea. The concept behind, the philosophy behind the class action lawsuit, in my view, is very valid. Anything and everything can be weaponized. Anything and everything can be abused. And class action lawsuits are no exception. And the fact that something is abused doesn't mean that it should go out of favor or be outlawed, like in Switzerland. What are the good aspects of a class action lawsuit? But before I go into the mechanism of class action lawsuit and so on and so forth, I would like to tackle a bit the philosophy, the legal philosophy behind it. In the modern world, businesses, service providers, institutions are actually huge networks. We have networks of suppliers organized in supply chains. We have networks of customers Consider, for example, Amazon with its hundreds of millions, if not billions of customers. So we have huge networks. The organizing principle of modern business, modern government, modern consumership, the organizing principle is a network. Class action lawsuits are network lawsuits. They organize people in networks. And in this sense, class action lawsuits are highly responsive to the way modern business and modern government are organized. Number two, equity. Corporations and institutions can damage and injure millions of people with a single act. Each and every one of these people, each and every one of the complainants or the plaintiffs has been damaged, has been injured, but by a small amount. Consider, for example, a bank, a real case in which I've been involved. Consider a bank who overcharges each client $2 or $20. Now, you can't file a lawsuit for $20. It would cost you $2,000. It's stupid, so no one would do that. And yet, millions of people have overpaid $20 each. So the class action lawsuits allows for plaintiffs who are poor, plaintiffs who cannot afford the legal process, or plaintiffs who have been minimally damaged, allows them to organize. It creates a level playing field between the defendant, the injuring party, the party who has acted illegally or even criminally, and the damaged party, the injured party. Now there's a level playing field. When you organize 1 million people and they sue a single bank, their power equals the power of the single bank. So it restores equity in legal processes. And similarly, when you succeed in the lawsuit and there is some money in a settlement or in a recovery, if you divide this money unequally, if the first plaintiff gets all the money and the other plaintiffs don't get anything, that's bad. In a class action lawsuit, there is a pool of recovery, a pool of settlement. The damages paid by the offending organization, institution, or corporation, monetary damages. And then there's a pool, and the pool is divided equally among all the plaintiffs and all the complainants, with the exception of the lead plaintiff or lead complainant, who gets a bit more in some jurisdiction, not in all. Most recently in the United States, this practice has been outlawed. Next thing is efficacy. If a bank or an organization or a consumer company, consumer product company, imagine there's a producer or a manufacturer, or imagine there's a food processing facility and the product has damaged, poisoned people, harmed people, injured people physically and so on. Imagine. And let's imagine that there's 1 million of these people. If class action lawsuit is rendered impossible, then you would have 1 million lawsuits. Or you know what, 100,000 lawsuits. Class action aggregates small lawsuits, tiny lawsuits, aggregates them. Class action allows small-time plaintiffs and complainants, the average person on the street who cannot afford to spend hundreds of thousands of dollars on legal fees. The class action lawsuits allows the complainants and the defendants to share resources, to share a single attorney, a single legal process, single fee, and so on and so forth. So there is resource sharing, and there's a sharing of the settlement. It's a sharing experiment. And because it's shared among hundreds of thousands, tens of thousands of people, the cost to each individual is minimal and usually zero. It's zero because in the vast majority of class action lawsuits, the attorney gets a percentage, a success fee, a percentage of the ultimate settlement or recovery, if there is any. If the class action lawsuit fails, the attorney does not get paid at all. So in majority of class action lawsuits, there are zero outlays, zero expenditures, and a potential for compensation, ultimate compensation, shared equally among everyone. Courts also like class action lawsuits because they make the life of the judge and the prosecutors and you name it, the apparatus, the legal apparatus, operates much more efficiently this way. The court doesn't get clogged by hundreds of thousands of lawsuits, but by a single one. One could view class action lawsuits as a form of entrepreneurship. The law firm, the attorneys that represent the complainants and the defendants in the class action lawsuits, they are venture capitalists. They are like incubators of startups. The lawsuit is like a startup. The attorney or the law firm invests in the startup. They invest in the lawsuit. They don't charge money. On the contrary, they put in their resources as a venture capitalist would do in a startup. And then if the startup succeeds, the attorney becomes rich and everyone gets compensated. This is actually the classic model of venture capital. We could consider class action lawsuits as venture capital in the law, legal venture capital. And finally, the very prospect, the very threat of class action lawsuit modifies the behaviors of corporations and institutions and organizations. They know that if they misbehave, if they injure people, if they damage people, if they sell defective products, if they engage in fraud, they're going to pay the price. They're going to pay the price through class action mechanism. And so I think it's extremely unfortunate that class action has fallen out of favor in many jurisdictions, and in some of them has been actually banned explicitly or implicitly through alternative mechanisms such as arbitration. Take arbitration, for example. It costs a fortune to go to arbitration. Who can afford arbitration? The bank can afford arbitration. High-tech company can afford arbitration. A multi-billionaire can afford arbitration. The average person on the street cannot afford arbitration. So they just let go. They turn a blind eye to their own damage and injury and they walk away. I don't think arbitration is a reasonable venue for complainants and plaintiffs to act against massive corporations and banks and financial institutions, government institutions, and so on. I don't think so at all. I think by effectively reducing the role of class action lawsuits, we have taken away a major tool, a major defensive tool from the hands of day-to-day average people all around the world. And that's not an accident, of course. Throughout the world, the legal system is becoming more and more biased in favor of the rich and powerful and against the common Joe, against the common person. That's a process that is happening all over the world, in the United States, in the United Kingdom, in Israel, you name it. The courts and the laws are biased in favor of the rich and powerful and mighty, and they discriminate against people who have been injured and damaged but don't have the wherewithal, don't have the financial resources to fight back. Now, I will discuss a bit the mechanism of the class action lawsuit. But before we go there, class action lawsuits are good at tackling the following problems: illegal labor practices, dangerous products, in other words, product liability and personal injury lawsuits, environmental concerns, health concerns, financial fraud, especially securities fraud. And in America, in the United States, class action lawsuits are still common in cases of securities fraud. And there's actually a law, I think dated 2015, there's an act that encourages class action lawsuits in securities fraud. That's the only enclave where class action lawsuits have survived somehow. Negligence, especially criminal negligence. We're seeing this with Boeing nowadays, potentially. Sports, injuries in sports, and so on and so forth. And above all, the number one class action lawsuit type is consumer. The consumer class action lawsuits. Now, class action lawsuits can be, as I mentioned, product liability lawsuits. They could be misrepresentation lawsuits, false advertising. They could be antitrust lawsuits or monopoly lawsuits, and so on. But consumer lawsuits. In Europe, class action consumer lawsuits are actually encouraged via Directive 1828 of the European Union, as I mentioned before. There are law firms, legal firms, that specialize in class action lawsuits. That's all they do. And the most famous law firm in the world which deal with the class action lawsuits are Hagens Berman, Hagens Berman, Berman. They have 100 lawyers. All of them do class action lawsuits. They are based in Washington, but they have branches in the European Union and elsewhere. And they are the leading world experts in class action lawsuits. Now, we go to the mechanism of the class action lawsuit. It's not easy. Filing a class action lawsuit is not an easy process. It's extremely difficult. That is why academic studies have demonstrated repeatedly that class action lawsuits are not used for extortion and blackmail, and the claims made by legal scholars such as Posner and others that these claims are counterfactual. They're conspiracy theories. They're not true. And the reason they're not true, as I said, is because it's very difficult to file a class action lawsuit. I know from personal experience, for every class action lawsuits I've been involved in, I have failed in 9 others, and I'm not exaggerating. I've failed to file. I've failed to be certified. So now let's explain the process. First of all, you need to have a complaint. You need to have a reason to file a class action lawsuit. You need to have a tort, basically, T-O-R-T, yeah, a tort. So the lawsuit is based on some damage or some injury or some oversight or some action or some inaction of an alleged defendant. You need to identify the defendant. It's not as easy as it sounds. If you have a corporation with multiple subsidiaries, numerous affiliates, supply chains, multiple holdings in shell companies all over the world, it's extremely difficult to identify who did what to whom, why, and where. So this is stage 1. You need also to prove to yourself as a law firm, first and foremost, you need to prove that the damage and injury done to people was identical. You can't aggregate non-identical damages and non-identical injuries. They need to be identical. So the first stage is finding a law firm, such as Hagens Berman or someone else, and this law firm conducts due diligence. It demands disclosure from the plaintiffs and complainants who come forth, and it conducts due diligence. Is there an identifiable defendant? And are the injuries and damages identical? How many people are involved? In some countries, there's a minimum of 40 people, or so on. So how many people are involved? How many of them know that they have been damaged and injured? In most cases, the vast majority of potential complainants and defendants are not even aware that something is wrong. And how many of these people are willing to get involved in the process? So that's stage one. Stage two, the law firm selects a face, a public face of the class action. This public face is a complainant or a plaintiff who has been damaged, who has been injured in a way that is identical to all other people in the same class. And this person is willing to be the public face of suing the defendant. Now, suing the defendant can sometimes be dangerous. Defendants don't take kindly to such lawsuits. If you sue a government agency, if you sue a bank, a major bank, if you sue a corporation, they could get nasty with you. So you need to convince, as a law firm, you need to convince someone to be the public face of the class action lawsuit. And this person is known as class representative or lead class representative. This kind of person, in some jurisdictions, gets overcompensated if the class action lawsuit succeeds, because this person has to invest a lot of time and effort and assume many risks. Then the next stage, you go to court and you ask the court to accept that your case is a class action case. You ask the court to certify it as a class action. And the court, if it agrees, and in the vast majority of cases, courts don't agree to grant the lawsuit a class action status. But if the court agrees to do so, the court issues a class certification order. And the class certification order affirms and confirms that a group of people represented by the law firm have a proper legal claim against the alleged defendant, and that the lead plaintiff is approved as representative of the kind of injury, kind of damage, kind of claim that applies and appertains to all other members of the class. Then it remains to be determined what is the size of a class. Are we talking about 40 people? Are we talking about 40,000 people? Are we talking about millions of people? And in which jurisdictions? In a single country, all over the world? It's a jurisdictional mess. And in some countries, you can sue only in a specific location, representing only people in that specific location. You cannot sue on behalf of people out of state, out of the region, out of the city, and so on. So there are jurisdictional issues. And remember, most of the defendants in these cases are multinationals. Multinationals. They have production facilities in India and in the United States and in Mexico and in Israel. They have a research facility in Israel. They employ people in 17 countries. They employ 170,000 people. They operate in a million ways. It's a mess. It's a huge mess to sort out. So don't jump. Jump of happiness that you have a class action lawsuit available to you, because it's a huge amount of work. You need to prove that the class is identical. All members are identical in terms of injuries and damages. And this also is not easy to do, because each member of a class has his own personal circumstances, his own income, her own preferences and priorities, her own experience with the product or the process or the service, etc. Homogenizing a group of 40,000 or 400,000 or 4 million people is not an easy thing to do. It's the size of a small country. Having overcome all these massive obstacles, the class action lawsuit is certified by the judge. Now you have a class action lawsuit. You have to inform all potential complainants and plaintiffs. You have to publish in the media, traditional media, social media, online and offline, and by direct mail. You have to inform everyone who potentially could join the lawsuit as a member of the class. You have to inform them that there is a class action lawsuit. At that point, they can opt into the lawsuit and they can opt out of the lawsuit. because they wish to sue the defendant separately, or because the circumstances are different, or because the injuries and damages, they value them differently, or they are different, etc. So everyone who is a potential member of the class can opt into the class and can opt out of the class. And then, and only then, the trial starts. Now, majority of class action lawsuits end in a settlement out of court. But the settlement has to be approved by a judge. And if the judge thinks that the attorney, the law firm that represents the class action lawsuit, has made a dirty deal with the defendant, which happens from time to time, the judge will disallow the settlement. And if the judge believes the settlement does not reflect the interests of the injured and damaged parties, the plaintiffs, the complainants, the judge will not allow the settlement. And if the judge thinks the settlement is too small, the judge will not allow. There are many reasons for the judge to disallow the settlement. And then, having overcome this, you have a settlement. The settlement is converted by the judge into a verdict, and a notification of settlement is published again everywhere, so that any member of the class is able to partake, able to get his or her share of the recovery, of the settlement. And there is a time limit. You need to file your claim as a member of the class within the time limit. And if the time limit is expired, you're unable to do so. There's a damages payout to everyone who have filed their claims by the appropriate date. That's the end of the class action lawsuit. And no one can sue the defendant after that. No one can sue the defendant afterwards for the same offense, for the same problem, for the same damage, for the same injury. So defendants are protected. It's kind of double jeopardy. Defendants are protected from future lawsuits and so on via the class action mechanism. That's in a nutshell an introduction to class action. I wish you a productive class, not action in the class, but not class action. So I wish you a productive class.